Welcome to Dad Talk Today. The podcast for dads facing some of the toughest moments of their lives. We are here to walk with men through divorce, keep them connected to their kids, help them understand their rights, and work for change in family law courts. Moms, you are always welcome too. We are all about advocating for shared parenting and doing what is best for our kids. Here is your host, Eric Carroll.
Everybody, welcome to Dad Talk Today. I'm here with Mr. Kevin Hickey. Kevin, what's going on, man?
Hey, not a lot. How you doing, Eric?
Doing all right. Well, guys, we're going to do the live Q&A. Nothing about this creates a client-attorney relationship. Even though you're getting your questions out to a professional, it's not to be taken as professional advice. Getting into that, sounds like you had a few things go on over the weekend. Can you tell us a little bit about that, Kevin?
Yeah, we had a webinar with a couple of different organizations. I'll try to get their names to you here before the end. But had a really good webinar on parental alienation. Had 2 or 3 experts on there. We had Rod McCall on there, who has just a tragic story from Texas involving he finally got custody of his son, and the judge allowed the son to go home with the mom and to say goodbye, and the mom ended up killing the child and then committing suicide. And he had endured alienation for years, and just a tragic story. But I think there's a lot of good momentum as far as parental alienation, getting the phrase out there so people understand what it is and the behaviors that are behind it, and that you just can't. We've got to start fighting this and try to get the wave going the other direction, because it seems like violence is becoming more and more associated with parental alienation, and it's just really unfortunate.
It definitely is. The stories do not stop. They're coming around the clock, and it's a hard thing to read about, guys. For anybody that can make it, now later on this week, me and Kevin will be in Lewiston, Idaho, where this all went down with John Mast. That'll be this Friday. We're going to be holding a little rally outside of the sheriff's department, talking to some of the locals about what went down in his case. If anybody can make it, we'd love to have you there, and hope to see you there.
I think that's at 8 a.m. local time, right, Eric?
8 a.m. local time. We should do that. I think we're going to be doing that until around 10, and then we'll go to a restaurant after that, where you guys can come and meet and greet with the podcast. You want to tell a little bit about your stories or something, we'll do that till around noon. Then we got to hop on a plane in Spokane. We're going to D.C., and we're holding a rally the next day in Washington, D.C. with Women Against False Accusations and the National Coalition for Men. They're supposed to be doing a moment of silence for John as well, and we'll have some footage of that for you guys. So if you can make any of that, please make it down there with us. But, you was talking about some of the things that we've got to clear up when it comes to parental alienation. What are some of those things that you was talking about, Kevin?
Well, I think that education for everyone involved is a huge factor. One of the things that happened in John Mast's case that I think was really, really unfortunate was the mother, who was the alienating parent. John was the target parent. She took the children to a counselor, and the counselor immediately believed what the mother was telling and what had allegedly happened to the children, even though it wasn't true. And she immediately started treating these children as if they had been sexually abused. And you can't do that. As a counselor, you have to understand the situation of what's going on with these children, what's going on with this parent before you start providing counseling. And it's like starting to give chemotherapy to a patient before you've determined if they even have cancer or not. You've got to understand the dynamics of what's going on. And I think one of the things we talked about over the weekend in the webinar that's so important going forward is education for mental health professionals, so they can identify what would be a high risk situation for false allegations. The vast majority, the research is clear, it's the same year in and year out. The vast majority of false allegations, whether they're just false physical abuse allegations or false sexual abuse allegations come out of situations where there's a highly contested divorce or custody situation. And mental health professionals need to do some kind of a screening when they see that there's a custody case going on, to see if these children have been coached. Have they been around a parent that is constantly talking negative about the other parent, engaging in all kinds of different alienating behaviors? We need to start educating mental health professionals to look for these kinds of signs before they start treating these children. Because once you start treating them as abused in some way, they can start to get the mindset that they actually were abused when it never even happened. And it causes more harm than good. So that's one of the big things we've got to start looking at is education.
Absolutely. We got the first question coming in here for you. And guys, if you got some questions, put them down in the comments. I'll take them to Kevin. We got one here from Kevin Williams. He said, my oldest daughter went to the hospital for suicidal ideation Friday. I asked her mom how she is doing through talking parents, and she has not read it or let me know what's going on. Should I do a welfare check on her?
I'm guessing, and Eric, you may be familiar with that, is Talking Parents one of the like a My Family wizard kind of thing where you can communicate?
Yeah, I think that's one of the other parenting apps.
I think if she's if you know for a fact she went to the hospital for suicidal ideation, yeah, I would do a welfare check. I would go to the hospital. I would do anything that you can. That child is just as much your child as it is the other parent's child. And you've got every right to try to see what's going on with the health of the child. So I would ask for a welfare check, and then I would also go to the hospital.
Yep. It's got to be a hard one. I mean, what's some of the consequences with that when the parent is not communicating through that app?
It's not necessarily illegal, but if they're using that app, a lot of times that comes about from an order of the court. The judge has ordered them either through an agreement they made or the judge felt it was necessary. It's in the order they're supposed to be using that communication software, and there's a reason for that. And judges get pretty upset when you don't. We've talked about this before. If you're not following the orders they've made, they get pretty upset about it, and especially with this serious of a situation. If the mom's not communicating with you, the judge is I just can't imagine that the judge is not going to be happy about that. It's going to be pretty upset.
Yeah. And I mean, communication is so critical. You know, I'm actually a pretty big fan of those parenting apps. What about you?
I think they're very good. You can keep a running tabulation of communication. And then there's a text was deleted or an email was deleted or something was changed. I think it can keep a really good running history of what the parties are saying to each other. Some of them will actually, as you're composing your message to the other parent, will actually give you little indicators and put little red flags up if it thinks you're using language you shouldn't use or saying things you shouldn't say. So it can help you kind of redirect or rephrase what you're sending.
Right. So we got some good news last week. I know that was something that you was involved in, Kevin. I think you gave a testimony on that. Sounds like Arkansas has passed their shared parenting bill. Can you tell us what you know about that?
Yeah, that's exactly right. It was a Senate bill, and so it came out of the Senate and went into the House, one of the subcommittees or one of the committees in the House. And I did write a letter on behalf of the bill. I thought it was, in years past, I was not a fan of the way the bill was worded, the way I read it. This year, I was okay with it. It looked pretty good to me as far as a shared parenting bill. And so sent a letter down there in support. It got out of committee in the House, went to the floor of the House, passed the House, went immediately back to the Senate and passed there again. And is on its way to the governor's desk is my understanding. So yeah, we're going to have a shared parenting bill here pretty shortly in Arkansas, shared parenting law. Yep.
And for anybody that's not familiar, what that bill is going to do for these parents in Arkansas, what is it that bill is going to provide for them?
Well, it helps put parents on equal footing. It starts off with a presumption that there should be joint custody unless you can show evidence that there shouldn't be joint custody. This levels the playing field a little bit with parents. A lot of parents have felt like there's been a bias toward one gender or the other in different courts and with different judges. This law will help put these parents on equal footing. Some of the negative comments about the bill had to do with that certain parents that have either domestic violence history or maybe some kind of deviant sexual behavior history would be immediately put on equal footing. But I think there's a section of the statute that keeps that from happening. It helps put those kinds of people, those kinds of parents that have been bad actors in the past, they're not going to automatically be given any kind of joint custody. There's a presumption against those kinds of people having any kind of extra custody rights.
Right. And that's something it's been so needed. And I've always said, if we can get a couple of these states knocking these out, I believe it's just going to start falling down like dominoes. I know, just to give you guys a little bit of an update, I know West Virginia has gotten pretty close. I know Texas is just waiting on a hearing. Georgia was just waiting on a hearing. So it's a pretty exciting time. I think something is about to happen. I really do. And yeah. So anyway, guys, bring us some of your questions and I will bring those to Kevin. We got something from Miranda Wright. So I'm not too sure on the question here, but she said, no education silvers enmeshment plus enabling continuance of unresolved. Why curse is to strangulate bio for abandoning ground children in a death of a 19-year-old?
I don't even know what that says. I can't. Miranda, see if you can rephrase that. I'm having a hard time following what you're asking there.
Yeah, if you could rephrase that for me and we'll try to get that up. iTumbler on YouTube said, I have 45% parenting time and pay $500 in child support a month. My ex makes significantly more. How soon should I file for modification of visitation? I want 50-50.
That is a question that comes up a fair amount of time. And the reason is people will either go to court and get a visitation arrangement, and then not long after that, they want to change it. So when you ask how soon should I file for modification of visitation, if you were in my office, I'd be asked, my next question to you would be, when was the last time you were in court? If you were just in court 2 or 3 months ago, it's going to be very hard, and you're probably going to waste your money hiring an attorney that soon after you were just in court to try to go back and modify the visitation order. You usually need to let a pretty good amount of time go by before you go back. Or if something significant has happened that has changed the situation, a parent's work schedule has changed, or one of you has moved or something like that, that might have changed something enough that you could go back to court and ask for a modification. You just need to talk to a local attorney about that handles these kinds of cases, handles family law, and see what they have to say about it. On the child support, it depends on what state you're in. Every state handles their child support differently. Arkansas just changed their child support law last July, and we now look at the other parent's income, compare it to the paying parent's income, and then there's a formula they use to come up with what the child support should be. If you're at 45% time, you may be close enough to 50-50 to ask for some kind of modification. Just depends on how long it's been since you've been in court.
Now, do you find a lot of times when that request for modification goes in that something happens with it, or does that usually get caught up?
It depends on the situation, and I would say half of the child support consults that I do, we end up not doing anything because it's either been too soon since they were in court, or their income has just not changed enough one way or the other, either up or down, to go back to court and change it. You really just need to schedule a consult with an attorney in your area to talk to them, because they'll know what the judges usually do with a situation like you have. But yeah, if you've got enough difference in income or time with the children, if you're supposed to get 35% of the time, and for the last year you've been getting 50% of the time, judges will look at that and many times will modify your child support.
Yep. Matthew Edwards said, haven't seen kids in 2 years. I was an involved dad. Mom is alcoholic. She blocks the phones and filed for safe at home program. Can I get the judge to override and disclose where my kids live? I'm fed up. Missouri. Recommendation to get custody with her issues and lies. Kids don't want to see me. Now, I know that you only practice in Arkansas, Kevin, but let's see if we can give some advice to this gentleman right here.
Well, this is real interesting, and I will tell you this is the second time, and I think I know what he's talking about when he said filed for safe at home program. This is only the second time I've heard of a program like this, and the first time was in John Mast's case. I think he's talking about some of these parents, if they feel like, or if there's been domestic violence or they've alleged domestic violence, some states have a program where you can file to have your address and your phone number confidential. You don't have to give it out to anybody. And you register with this program. And then so if someone like Social Security or some state agency that's really entitled to that information, if they need it, oh, my light went out. If they need it, then they will have to apply to this program and get the information from there. But your address and phone number are not public. And I think that's what he's talking about, is that he has been part of that program, or she's part of that program, so he doesn't know where they live, doesn't know where his children are, and he hadn't seen them in 2 years. But there should be an order somewhere the last time you were in court saying that she has custody and you have visitation. And if that has not been changed, she's in violation of that order. She's got to comply with it. She's got to give you your visitation. And if she's not, then she's in contempt. You're just going to have to get an attorney and go back to court. But talking about John Mast's case, his wife, when she fled North Dakota to go to Idaho, she filed for that program, and that was another alienating stumbling block that she put in John's way to where he could not find the children. She filed for that program, so everywhere she lived, phone numbers, where the kids went to school, it was all confidential.
It's interesting you say that. I think a lot of times the spotlight is put on the brainwashing of the child, just straight out bad mouthing the parent. What are some other ways that parents alienate the children that some might not necessarily tie that with right off?
Well, that's one of the ways. They will, like I said, an alienating stumbling block. They'll try to put something in between. The ultimate goal is to get that other parent out of the children's lives. And the more they can push them away, that's what they want to do. So they use all kinds of means. One of her first means was to flee to Idaho, 2 states away. Then was to register for that program so that she could be, her address and her phone number would be confidential, and he wouldn't know where she or the children were. They'll cut off visitation time. The kids don't ever hear about that. They just know that dad didn't show up that weekend. They don't understand that mom is telling dad, well, you're not getting them this weekend. Try me, go to the police, whatever. Or they don't want to see you. All of that starts and it snowballs. So there's all kinds of ways that they can alienate you without just turning the children against you.
Yeah, I made a little post about that the other night. I was talking about, sometimes they'll give freedoms to the children that one parent won't, like letting them go off with their boyfriend or their girlfriend, let them have sex, give them all these different privileges, and it makes it look like the parent that's actually trying to enforce the rules, they're bad, they're against you. There's so many different ways that they can alienate guys, and you gotta be on top of that.
Yeah, absolutely.
Alan Eoff said, what could be the consequences for not bringing your financials to mediation?
Mediation is, it depends. If it was court-ordered mediation, a lot of times the judge will just say, you guys pick a mediator and go to mediation. 1 or 2 times in other states I've seen where there was a mediation order where the judge said, you're going to go to mediation and you're going to take X, Y, and Z with you and these documents and whatever. If the other person was court-ordered to bring those, then they need to bring them. If they weren't court-ordered, then they may not have been required to bring them. Now, both parties need to bring all the information they can when they come to a mediation. Usually those fees are split. You're both going to have to pay this mediator. And if you're going to have to pay the person and you're going to have to be there for it, you might as well make as good of a shot as you can at it to try to get the case settled. So when you only go with partial information, it really lessens the likelihood that you're going to be able to get your case settled.
Yes, sir. Hey, appreciate that, Alan. We got one in here from Brianna Harper. She said, my husband hasn't seen his daughter in 4 months after having his daughter half the week every week, and she has blocked him, enrolled her in school, and we don't have any information. We are located in Florida, and he is requesting 50-50. They have a pre-child with the GM 518. Is there anything else that could be done to have her sooner?
Seen his daughter in 4 months. We locked him. A pretrial. Okay, pretrial can mean a bunch of different things. Sometimes pretrial, and you need to ask your attorney exactly what this one is for. Sometimes it's just for scheduling, but other times it's for asking for some kind of temporary change, it could be a 50-50 change. It says with the GM, I'm assuming that's the magistrate maybe, for May 18th. I don't know about moving it sooner. In legal terms, in legal time, May 18th is not that far away. I know it seems like a pretty far time away, but if you already got a hearing set, getting one sooner than that, especially with the way COVID's been the last year and the backlog with the courts, I don't know if you'd be able to get one sooner or not.
Yep. We got one in here from Cello Rock. It's a little bit of a long one, Kevin. I'm going to try to bring this to you. I can't pull it up on screen.
Okay.
He said, I'm having a problem with my current attorney. I gave him an offensive plan as first start when he started to represent me, and my motion was full with solid evidence of mom's lies to court and child abuse by mom's boyfriend, with a medical record attached as an exhibit showing that the doctor made a call to CPS. The judge dismissed my petition requesting temporary custody modification till the trial, denied my access to my own proceeding, probably because she knew that I always say things on the record that she doesn't want to be on the record. The child attorney is not on the same side of the fence and making it all difficult. My attorney doesn't ever have a defensive plan if I don't come up with one, and he is also making it difficult by making himself unavailable and denying all my requests for an immediate defensive plan, saying that the judge will not make any decision till trial. So here I am barely having supervised visits, and my attorney in the court's trying to make me believe that I can't have unsupervised visits when I was not ever proved to be guilty or harm to the child. What should I do?
You need to set up a time to go meet with your attorney with all of these questions and put those questions out there directly to your lawyer and the concerns that you have. There was a reason that you chose this attorney to begin with. Something made you decide that this was the person you were going to go to battle with. So give them a chance to talk to you and give you a reason as to why he or she is handling your case the way that they are. And sometimes you have to switch attorneys, and I'm not telling you to do that, but you've got to believe in your attorney, and you've got to feel like you're on the same page with your lawyer. And many times, you're not the first client, but many times clients don't feel that way. And but always give your attorney a first opportunity to sit down with you and explain why a certain piece of evidence wasn't objected to, or why certain pieces of evidence weren't put into the record that you wanted. Let them explain to you why they made that decision. That's all you can really do is sit down with them. And then if you're not happy with those answers, or you feel like that there's just a total disconnect, you may need to look at getting a different attorney.
And let's talk about that for a second, Kevin, because I know I get accused of that a lot too, being unavailable. I get so many messages on here, and I know you guys do as well, because you got several different clients, and it's hard to be available all the time. And that's not taken up. I've heard from people that just can't get in touch with their attorney at all, and that's not acceptable, especially when you've got something going on. But
it's the number one complaint that clients have every year about attorneys is they can't get their attorney on the phone. We have hearings. Some of us end up having hearings every day, certain weeks. We've got numerous cases that we're working on. It's a very time-intensive profession, and it takes a lot of time to do all of that, and there's only so many hours in a day. And not making excuses for it, but it happens. And just understand that That is a huge complaint. And I know in our office, no one's perfect, but we sure strive to make sure that on communication, one of us gets back with a client as soon as we can, and try to get them the answer and the information that they're needing. But yeah, it's a complaint, and it's been a complaint for years about attorneys.
Yep. Matthew Edwards said, I hired a clinical psychologist. The biased guardian ad litem checked out. X won't cooperate with a custody evaluation. Does judge put out a lot of stock in these evaluations? Also, any general advice for being on court? Top 3 tips for success. I guess he's saying for being in court.
Right. I practice in Arkansas, and we do not have, we are not a state that usually uses custody evaluations. A lot of states really use them, and a lot of states use them routinely. And judges in those states will order custody evaluations to be done. My understanding, and this is just my understanding from attorneys I've spoken with in those states, yeah, the judges put a lot of stock in the custody evaluations. That's what they're for. Custody evaluators many times will go out and they essentially do an investigation and then give a report back to the court. So I would think the judge would put some stock in it. As far as the last part, top 3 tips, the biggest thing is be yourself when you go to court. If you start trying to act in a way that's not really being genuine, judges see people on the stand, tons of people almost every day. So one of the things that a judge gets really good at is judging people and judging their credibility, because they've seen all kinds every day. So be yourself. Be sure you look nice when you go to court. You don't. Every state's different. So talk to your attorney about what you should wear. You don't necessarily have to wear a suit. At least that's what I tell my clients. But you definitely want to dress business casual at a minimum. So you look good when you go to court. And there's a big reason for that. The judges are judging people and sizing up parties as soon as they come through that door. And you don't want them to have a first impression of you that you're not taking the court very seriously. So you want to dress for it and just be ready to go when you get there. Oh, another thing is judges are also watching parties when they're sitting at the table with their attorney. Don't be shaking your head or acting exasperated while a witness is on the stand, or grabbing your attorney and angrily or in an exaggerated way, talking to your attorney and whispering and writing stuff. The judges are watching all of that, and they're watching your behavior over there. And I can tell you 100% if you're acting that way, maybe even before you've even gotten on the stand, that judge already has a negative thought about you. Now, they'll give you a chance when you get on the stand, but when you're acting that way over there, they see it. So just be very cognizant of how you're acting when you're sitting next to your attorney at the table. And what I tell clients to do is, look, you're going to hear that witness testifying, and you're going to want to grab me and say, look, they're lying, and here's why they're lying. Your attorney needs to listen to what that other attorney is asking. They need to listen to what the witness is saying and deciding if they're going to object or not. Have a little notepad over there that you can write your questions down, and then when there's a break or something, then go over those with your attorney.
All right. Appreciate that, Matthew. We got one in here from Michael Deere. He said, I think you said, that said, I do file contempt charges against son's mother. What happens if the mom is found in contempt?
Contempt is what you use to show the court that one party is not following the court's orders. You are then what's called in contempt of court. A judge that's presented with that situation and decides that the party is in fact in contempt and violated the orders, they have an entire range of punishments they can come up with. And they range all the way from just slapping the person on the wrist and saying, now don't do that anymore. I don't want you to see you back in my court with this same problem again, all the way up to they could throw them in jail. Now, jail is the most extreme and the last resort for a judge. It depends on the contempt. It depends on what's happened. If it's serious enough, many times judges will order the person that's found in contempt to pay some attorney's fees for the other side. They could lose some privileges, maybe even some visitation privileges. There's all kinds of ranges of punishments that the judge can give. It just depends on how serious.
Yep. iTumbler said, our final order came in December 2020. Is the gal still my daughter's gal and can be brought in the future? How can I get him removed? He gave favor to my ex because her attorney works together.
It depends on the state that you're in, but most of the time, you said you got your final order in December. Usually that concludes the case. And in most states, once that case is over, all attorneys' representation ends unless your contract with your attorney says differently. Usually all attorneys, including the GAL, are discharged from the case. So normally in that situation, the GAL, your daughter's GAL would not still be assigned to talk to her. As far as getting them removed, what I've done, if we felt like there was we call them guardian ad litem, attorney ad litems. When we reopen a case and we feel like one was biased or didn't do as good of a job as we wanted, when the cases we reopened, we ask for a specific other ad litem to be appointed. And a lot of judges normally look to who the last ad litem was because they're familiar with the case, so they want to reappoint them. But I have been successful in asking for other ad litems before, and the judges will do it. But that's what you'll need to do is ask for a different one when you reopen the case.
Matthew Edward followed up. He said, supervised visits should only be for extreme circumstances. Yes. Seems the court loves this and never works with alienation. Have you seen with the supervised visits with alienated parents be that effective, Kevin?
The ones that are engaging in the alienating tactics or going to his first question, yes, supervised visits are only supposed to be for extreme circumstances. When I have a client mention to me and I want supervised visitation, I immediately go into questions with them about why we're asking for that. And a lot of times you find out that they're just mad at the other parent or not happy with them. There's no real danger of the children being around this parent. And in cases like that, judges are usually not going to order any kind of supervised visitation. They need to see that there's some harm to the children or potential harm that they're very concerned about before they'll order supervised visits.
Got it. This question cut off. I'm going to pull it up and then I'm going to read it the rest of the way for you. Jason Dodd said, question from Canada. Have you heard of uninterrupted possession status? Do you have any advice about the uninterrupted possession status? It is a law in Quebec, Canada, that says after 2 years of uninterrupted possession of a child, the presumed father cannot be contested. I've chased my son's mother from one side of Canada to the other side and back again. Had her in court after 3 years, and the judge proceeded with the case, but after my lawyer requested undertakings, her and the presumed father ran and constantly moved to hide from being served. Don't think there is anything I can do now, but make sure others don't suffer the same fate. Are you familiar with this, Kevin?
I'm not, Jason. I'm sorry, I'm not. It's sounding like it's a law that says that if you haven't been declared the father yet, if you have the child for 2 years of uninterrupted possession, then you're presumed to be the father, maybe. But I can't answer that. I'm just not familiar with it.
Yeah, sorry about that, brother. I mean, there's so many different laws. I know Canada is very similar to the States, but there's, they're called different things and stuff like that. But we'll try to find out for you. We'll try to find out. Frank Hand said, if I know nothing about custody and was served a notice from my ex about the kids, what do I do?
Well, I think you need to go talk to a lawyer. We've talked about this before. No one wakes up one morning and says, gee, I want to go talk to a lawyer today. That sounds like a lot of fun. No one wants to go talk to a lawyer, but many times you need advice. And if you've been served with a notice, that very likely could be some kind of lawsuit involving custody, the children, something. You need to talk to somebody that can decipher that for you and give you some advice. People are worried. They think it's going to be thousands and thousands of dollars and all this. Don't think that far ahead. Call around to an attorney that handles family law, handles custody. ask them if you can have 45 minutes, hour of their time, and you want to sit down and talk about this, and how much would that cost to go talk to them for that. And I think it'll be a reasonable price for you, and you can get some really good advice about what your next step needs to be.
You know, I don't know about that. I was looking forward to talking to you tonight. Yeah, it's okay.
Yeah, well, thanks, Eric.
We got a question from Eric Williams. He said, when an opposing attorney becomes so personally involved with a client that she becomes worse than the client and hurting your children's relationship with you, what do you do?
Oh, attorneys. I tell you, yeah, attorneys are people too. And we deal with, so every attorney we deal with is different, and they have different temperaments, and it's always good, and it's a pleasure, and it's really better for the clients when you have an attorney on the other side that you've worked with before, that you get along with, because you usually know there's not going to be any discovery problems. You're going to be able to work things out, as maybe some visitation issues, but you get an attorney on the other side that's very difficult to deal with, and getting very personally involved, like you say, and almost thinking more in a subjective way than an objective way. It can hurt the case. It really can. There's not a lot you can do except talk with your own attorney about it. Make sure that other attorney that you're concerned about is not crossing any lines ethically. Your attorney may need to talk to that attorney privately and say, hey, I'm getting a little worried about this or that or whatever. That as far as what you can do about it, you need to talk to your own attorney about it and the concerns, and see if anything can be done.
I appreciate that, Eric. We got another one
that happens. That happens more than people realize. I think everybody sees attorneys as, very hardcore and cold-hearted and all that, but in family law, we get very invested in these cases, and some attorneys go over the line. It happens, and so that's not it's not common, but it's not uncommon either.
Right. I got another one of those questions that got cut off. I'm going to bring it up and try to read it off to you. Andrea Sterling said, my husband hasn't heard from his daughter since December. When he texts his ex, she gives him a hard time and tells him he needs to provide a way for his daughter to communicate with him if he wants to talk to her. We do have a court order. He only gets his daughter 2 weeks for summer and alternating birthday years. If she has her primarily, shouldn't she be the one to provide a way for her to be able to speak with her dad? We did provide a phone for his daughter in the past, but now the mom states it has gone missing somewhere in their home. That's a new one. I haven't heard that one before. It's a great question.
Well, she doesn't necessarily have to provide a separate phone, but she certainly needs to provide a way to communicate, and she can provide her own phone. And most visitation orders talk about phone visitation these days, or FaceTime, or some other kind of virtual visitation. And you need to be able to communicate with your child. And if it's in the order and he's not getting his visitation, you may need to go back to court over it, or at least talk to an attorney about it, writing her a letter or something telling her she needs to get in compliance with the order.
Yep. I mean, she should have a cell phone of her own. There's got to be some ways that communication is happening. It sounds like an excuse to me, but that's just my opinion. I don't know what's going on in the case, but
that's another, Eric, we were talking earlier about tactics that an alienating parent will use. That's another one. Take the phone away, or they're not here, or I tried to get her to come to the phone. She didn't want to talk to you, or, and meanwhile, they never even asked the child if they wanted to talk to their dad or mom or whoever it was. So that's another tactic.
Oh, yeah. All right. Brandy Roar Johnson said, what can be done if your attorney keeps saying we are building a case? Bear with me. I have a court-ordered judgment with a parenting plan incorporated. It has been 5 years since I have had any time with my children. Should I fire my attorney and look elsewhere, or just file pro se?
Well, I never advise people to file pro se. Some people will end up in that situation because of finances or whatever. Sometimes it does take building a case. Sometimes you need enough evidence when you're going to go to court. One thing we learn after years and years of doing this is just how many pieces of evidence we're going to need. And I try to talk to clients about, we're trying to fill up a bucket with pieces of evidence. Every piece of evidence we find, we put in that bucket. And once we get to a certain level, then I feel like we've got enough to go to court with. So if I were to sit down and listen to your attorney and what he or she has to say and the evidence that you're presenting to your attorney, I might agree and say, you know what, you're going to need more. I may not. Every attorney looks at it differently. 5 years is a pretty significant amount of time. And, you may want to sit down with your attorney and just ask, how much more do you need? Are we ever going to get there? Do I need to just find somebody else and see what they say? You may be more comfortable with another attorney, but I think you need to talk to your current attorney first.
Gabriela Torres said, my stepsons have been living with us since last summer. They go to their mother every other weekend, and my husband is continually paying child support. He's still waiting for court appearance for her violating the court order continuously. Both lawyers and guardian ad litem signed for a temporary order for the boys to live with us last August. Will he be able to get the child support reserve back to him? We are $25,000 in debt.
Well, what should have happened probably is there was a motion to either end the child support or modify the child support back around the time that temporary order was entered, or it's included in the temporary order. Sometimes if there's, and it sounds like this may be a wage withholding, like a garnishment, which is pretty common, that will continue until a new order is entered that terminates it. So normally, I know that's bad news, but the good news is normally you can go back to when you filed your petition to have it terminated. So if that's the case, or it's in that temporary order, once it stops, you should get some kind of retroactive relief, so that going forward, you'll either get paid back, or if the other parent's supposed to be paying you, something along those lines to somehow get that money back. But that needs to be looked into. It's been August since temporary order. It's been a while.
I'm kind of curious about that with child support. I know one time I was working 2 jobs. This has been years ago, and child support started taking out double payments. On my second job, it was taking out the full child support in that job, full child support in the first job. And that went on for a year, even though I was calling them and saying, hey, I'm already paying it with this job. And they wouldn't give me that money back. Finally, the only thing I got out of them is they said, you'll stop paying so many months before the child turns 18, which I wouldn't count on that either.
Well, keep track of it.
Yeah. Jeremy Wise said, why won't they press charges on a mother that left the state using a restraining order and had an order to not leave state?
Well, I think they will. You've got to file something in the state where you are. If she's ordered not to leave the state, you need to file something with the court to do something about it. And this is a little bit of a frustrating deal. Again, referring to John Mast case, his wife took off with the kids and went to Idaho. North Dakota's statute is very clear. You have to ask for permission from the court before you do that. And up to this day, up until that case was over, she never did file for permission to leave the state of North Dakota. And we put that in our brief to the judge to point it out, and he didn't make a ruling on it. So some judges just, it takes a lot to get them to move the needle, and leaving the state to me is one of the most, I don't want to say offensive, but that's one of the most aggressive things you can do, especially when a case has been filed, because you're now under the jurisdiction of the court when that case has been filed, and you're just basically thumbing your nose at the court and taking off across state lines. And if I were a judge, I'd be taking it very seriously and trying to get that parent brought back, for sure.
I just got to ask, what do you think would have happened if that would have been John that done that?
Well, we know what would have happened. She would have raised all kinds of cane with the police and prosecutors and everybody else. He, at a minimum, would have been ordered to bring them back immediately, and at the most, he'd probably have been arrested. I mean, it does seem to be a double standard.
It definitely does. Frank Hand said, if a judge takes away time due to contempt, may that be retaliation, and judicial scope may be shed, which may open door to federal court.
Time due to contempt. I think he's asking if a judge takes away time because of contempt, is that some kind of retaliation by the judge, maybe, for not being happy with that party? I wouldn't think so. Judges have a lot of discretion, like I said, to craft a contempt. The purpose of contempt and the reason a judge will find someone in contempt is because they violated the order. But what they want is to get that person in compliance. So is it a punishment? Yeah, it's a type of punishment, but their ultimate goal is, I don't want to see you back here again. I'm hoping you learn a lesson and that you start following my orders. So that's what the purpose of the contempt is.
Absolutely. Jeremy Lake said, visitation privileges. Why should anyone be granted visitation privileges instead of God-given unalienable rights to raise their children?
Well, when you are married, you get what? You get a certificate from the state, and that legally marries you. The state granted that marriage. To undo that thing that the state gave you, that privilege of being married, they have to do a divorce. And so you have to go through court to have them undo what the state did. You have to have the state undo what the state initially put together. And part of that is putting together custody and visitation rights, and what the parties are going to be doing now that they are not a union anymore, now that they're not married anymore. So that's why you have to go there instead of just having these inalienable rights to raise your children. When there's a situation like that, the courts have to get involved if there's no way to come to an agreement with the other parent.
Yeah. Frank said, if supervised visits are ordered for punishment, is that retaliation and judicial immunity may have been shed? I think he was referring back to his former comment.
I don't think so. But Frank, every case is different, and I would have had to have sat in that courtroom and see. I think you're talking about the temperament of the judge, and that the judge was retaliating by ordering these supervised visits. It's hard to prove that retaliation. Judicial immunity, we've talked a little bit about that on here before, how hard it is to go after a judge and get around immunity, to sue a judge or go after them. It's nearly impossible. And something like this would not rise to that level.
Yeah. Brandy Johnson said, Mr. Hickey, what can be done when an alienated 16-year-old takes a gun after the targeted parent in front of the alienated parent? CPS was informed they said that is not a report because everyone in North Dakota has a rifle.
Well, to me, that goes back to the education thing. I had a situation with a client. She was picking up her daughter from school, and her ex had some mental issues and showed up to the school and shot a gun in the parking lot. It did not harm either one of them or anybody, thankfully, but it hit the car. There's a bullet hole in the car. He got arrested. We filed a motion to have his visitation completely taken away. And I made the point to the judge that, Your Honor, no one was hurt, but that doesn't excuse what happened. We're just lucky no one was hurt. We're lucky no one was killed. And you can't, if you just pass this behavior off without doing anything, then you're encouraging it. And I don't care what state it's in, a gun can kill somebody, seriously injure somebody, take away a child's parent forever, take away a child from a parent forever. And I don't care how many rifles are in North Dakota or whatever state, that is a serious matter. And if that happened, it needs to be dealt with seriously.
I agree. That's not something to play around with. Debbie on YouTube said, what can my son do to get the mom to pay her child support for the last 3 years? Well, she works.
You can there's two things you can do. You can either get an attorney and take her to court, or you can go to, in Arkansas, it's called the Office of Child Support Enforcement. Every state has an agency of some kind that will help you enforce a child support order. That is a lot less than having to hire an attorney. Usually they have an administrative fee you have to pay, and you got to understand that you're going to be one of thousands of clients that they have. But it does cost a lot less to use that agency. You can go there and tell them you're having problems collecting child support, and they'll open a case for you.
Yep. All right. So, Kevin, we got an age-old question right here, and I know this might be a little bit of a gray area, but Brenda Padot said, "Why are judges so biased against fathers?"
Oh man, I don't know. You could probably answer that. I don't know. You've dealt with this stuff a lot.
Oh man.
I think there's just a lot of, every judge would answer that differently. Every person would answer that differently. Just my opinion is there's a lot of the old ways still out there. For decades, the mom was the stay-at-home person, the nurturing person, and the dad had to go out and work. And our society has just changed. And but I think many times the moms are seen as the more nurturing side, and so that's one bias against fathers, and that fathers just are not as nurturing. I'm not saying it's true. I just think there's kind of that perception sometimes.
I think that a lot of the judges were brought up in the old school, and that you got the Duluth model that had a lot to do with that. The power and control wheel that was basically said 90% of the time the father is going to be an abuser, he's going to be a cheater. I know you've probably heard a lot of testimonies, people saying that when they testify against shared parenting, we're going to be rewarding rapists. We're going to be rewarding all these different people because they're afraid that fathers are going to get custody. And there's a real bias when it comes to that. You get Title 4D of the Social Security Act. There's incentives that the state gets from the federal government for, money that's paid on child support. And it's in their best interest to make sure the person that's got the most money is the one that's paying. That would be my best answer for that one. And I'm sure there's a lot more that goes into it.
And I want to kind of applaud the judges that I'm in front of the vast majority of my career, which is in my area in Arkansas. I feel like we really get a fair shake, even when I'm representing fathers. And we've gotten numerous fathers custody of their kids. And I feel like that I've been doing this 21 years, and compared to 21 years ago to now, I think we're light years further along now, at least in the areas where I primarily practice, in making parents more equal, a little bit more equal playing field.
Well, they just passed the shared parenting bill, so that's proof of that. Arkansas is kind of leading the charge, guys. So I'm glad to hear it. Nikki Ward said, "Have you ever seen a judge just flip custody and switch the parent status, specifically with custodial parents who alienate?"
Yes. Yes. And usually it's not the first time you go back to court. It can be after one or two or three times, unfortunately. But judges recognize this behavior. Some have a hard time seeing just how damaging it is. But even if they don't know the word alienation or parental alienation, they know these behaviors of one parent trying to undermine the other parent and essentially cut that parent out. And they don't like it. They want both parents to work together. The children did not ask for this divorce. They don't deserve their parents to be pulling them both directions. They are entitled and have the right to have two parents that love them and are encouraging them to have a relationship with both parents. So yeah, if a judge sees and continuously sees this kind of behavior from one parent and thinks the children are being harmed by it, absolutely, I've seen a judge change custody before.
Yeah. This is a hard one to read. Jason Dodd, he said, "Little more information. I am the father, but another man signed the paternity acknowledgement. It's a paternity fraud case where I'm trying to prove my paternity to my son." What solutions is there for someone that has claimed to be the father over the biological father?
Well, first of all, Jason, this is not something you're going to be able to handle on your own. And I'm not saying that you're saying that you are, but you're going to need to get an attorney involved, because if there is fraud going on, you're going to have to get an attorney to find which court you're going to need to file that in, either in the county where this paternity acknowledgement was signed or whatever. And, that may be a totally different county from where your son is living now. You're going to have all kinds of legal issues you're going to have to wade through, but you need to file a paternity action. That's having you declared legally the father. And you're going to need to serve the mom, find where she is and serve her. And you're probably going to have to serve this other man that signed the acknowledgement of paternity. and he's going to have to be made a party to it too, which is not normally what we do. But he needs to be a party to it also. But get an attorney as soon, and you need to do that sooner rather than later, because that's not a situation you want to leave lingering out there for very long.
Yeah, man. Hey, and Jason, I would tell you, tune in tomorrow, guys. We've got a guest that I was so honored to interview, Kevin, Dr. Ben Carson. And little known fact that a lot of people don't know about him, he was close to being a victim of paternity fraud. A woman tried to claim that he was the father of their child. The thing was,
okay, I didn't know that.
Oh yeah, and we talk about it in full length on the shows, and there's a lot. He's more familiar with your issues than many people might know, but the good thing was he's never slept with anybody but his wife, so he was ready to fight that.
That's good. He just seems like a really genuine, nice person. That's all. That's anytime I've ever heard him speak or talk or watched him or whatever. He just seems like a really, really good person.
It's very rare that you talk to a politician that's so humble and genuine. I mean, I really enjoy talking to him. But tune into that because he, very similar, man. Cello Rock said, my attorney denied my request to attach an amicus brief to my petition of custody modification, which was made by the best expert witness in New York. I'm sure not would put some weight on my petition. Was he right by denied my request? Would the amicus brief hurt my case? Well,
here's the deal. And this is something we sometimes go back and forth with clients. Your attorney probably had a very good reason for not attaching it. And sometimes you don't want to show every card you've got right from the very beginning. And some clients don't understand that this is sometimes a marathon, not a sprint. And so when I'm filing things and putting stuff out there, I want to put enough out there for the court to know what we're asking about. But I don't want to show every card that we've got because I don't want to give the other side an opportunity to prepare for it. So if you've taken the time to get this amicus brief, I'm going to assume that it's very, very good from this expert that you've got and incredibly helpful for your case. Your attorney may not want to show that card yet. You don't want to give that, because if I see all of that from the beginning, when I'm on the other side as the attorney, it helps me because I can see almost your entire case before we even get into discovery. And so I've had months instead of days or whatever to start planning how I want to cut through the arguments that you've got and your position in your case. It just gives me more time and more opportunity to find arguments to get around it. So you might ask your attorney about it. But I'm betting that's why they didn't want to attach it, either because it was extraneous information that you don't need yet, or something like that. But understand too, that by no means means that that's not important. It's probably incredibly important. There's just a right time to present it, if I had to guess.
Yeah. Karina Edith Aravalo said, if a parent gets custody of one of their teenagers in family court and two children are in foster care, can and will that make a difference in dependency court to help bring the younger two children back home?
I can't help but think that it would help, Karina. I think that the more you can show that the kids that are in foster care are going to be okay when they come back home, the better. And that's going to help the dependency court understand that your home is safe. Whatever caused any issues to begin with have either been alleviated or you fixed or solved or whatever, made the situation better, the home environment for the children better. If you've got custody of one of them, I would think that would definitely help. And that, as your attorney, that would be something I would want to bring up to the dependency court.
Jeremy Lake said, are there any times where you would advise someone proceed sui juris? Because being under representation actually removes your inherent rights. Example, ex parte order for protection.
Sui juris, I have not heard that phrase in a long time, and I cannot remember what it means.
Sounds like an appetizer.
Yeah, it's very good. Yeah. No, I just can't remember. Sorry, Jeremy, I can't answer that.
Yep. So I can't find the question, but somebody was saying, why does affairs not matter inside the court anymore?
Well, that's a good question. I don't know if it's become just so much more common, or judges have just gotten jaded with it because they seem to hear about it a lot. If you're talking about custody, the usual argument is because someone had an affair doesn't mean that they're a bad parent. And until you can show that somehow affected their parenting ability and harmed the children, then it's not as huge of a factor. And if you ask a judge that directly, they're not going to say, oh, it doesn't matter at all. They're not going to say that. It's in their mind, but it does seem to be a lower factor for them than a lot of other things do.
Yeah. Michael Nacarino, I hope I said that right. He said, hi, I had a judge rule against me in every way, including taking my 11-year-old away from me. I did not have an affair or file for a divorce in New York. The judge has ordered me to pay $66,000 for the last 15 months of expenses, which is $4,400 a month, which is $300 more than I take home. I need help, please. Is there any advice you could give to Michael, Kevin?
God, he needs to talk to somebody about getting that reduced. I don't see how the judge could order that. The judge must have thought there was some other kind of income coming in other than the $4,400 a month you've got, because otherwise, I don't know how the judge would have expected you to pay that. So you just need to talk to your attorney about getting some kind of reduction. That's about all I know to say on that.
Yeah. Ronnie Knowles said, why does it matter if you leave the state?
Well, because a state's orders only they end at the state line. So in Arkansas order, we have Oklahoma right across the border from where I live in Fort Smith. You go over to Oklahoma, and an Arkansas order is not going to be effective over there. So judges want you to stay in the jurisdiction where they have control over the case and control over the parties. So if you leave the state, it's like it's an indication you're trying to avoid the authority of the court. And so it's definitely a problem.
He also followed up with that and said, do we not follow the United States Constitution? Does the Constitution matter anymore?
Yes, it does. And there's a lot of federal laws that prohibit you hopping over a state line. One is it's the UCCJEA. It's a Child Custody Jurisdiction Enforcement Act. That's a federal law that every state has adopted. And basically it says, let's use the Arkansas-Oklahoma example. Let's say we're living here in Arkansas, and the husband takes off with the kids and goes over to Oklahoma and files for divorce over there, trying to get his divorce taken care of over there. Most states have residency requirements. You have to live in a state for a certain amount of time. Some it's 30 days, 60 days, some it's 6 months or longer. This UCCJEA, that's a federal law, says if you've got a child custody issue, you have to be in the other state for 6 months before you can have that situation heard there, have that case heard there. Otherwise, it's got to be heard in the state you just left. So yeah, it's not really the Constitution, but it is federal laws that help people on a state level in that situation. And going back to John Mast's case, that helped him in his case. A wife took off from North Dakota to Idaho with the kids. He filed for divorce in North Dakota, served her with the papers. She didn't care. She tried to file in Idaho, and the judges got on the phone from North Dakota and Idaho and decided she hadn't been in Idaho for 6 months, so they kicked it back to North Dakota, and that's where the case stayed.
Yeah. Nathaniel McKnight Jr. said, what happens when the plaintiff does not show up for a hearing?
It depends on the hearing. Most judges, if you just don't show up, are not very happy about it. It's a clear indication you're not taking the situation or the court's authority very seriously. So they're not very happy about it. If it's a final order, if it's a final hearing, many times they can essentially be in default, and the judge can award the other party that showed up pretty much whatever they're asking for. You're running a big risk when you don't go to court when there's a court hearing set.
Eric Williams said, Kevin, as we talk about supervised visits, how often do you see them ordered on moms in comparison to dads?
It just depends on whoever has custody. The other one is getting the supervised visits. It is normally dads. I would say it still leans toward moms as far as having more custody than dads do. A lot of that is just part of society. You got to remember, over 90% of cases settle before we ever get to court and have a judge decide it. So sometimes the parties come to an agreement that ends up with one of them having custody or having the children more than the other one.
Yep. Got one from D-Rock Cast. It's kind of following up with what we just answered. CPS recommended my ex have supervised visitation and me custody. Judge gave us 50-50. I feel the system is biased. Am I wrong?
I don't know if I'd say you're wrong. The key word there is recommended. Anytime that you're going to court, the final say-so is going to rest with the judge. And the judge will get recommendations from custody evaluators, CPS in this situation, guardian ad litems, attorney ad litems. But the judge has the final say-so. And if the judge feels like something different needs to be done, then they can order something different. That's the best way I can answer it.
Yep. All right. Ooh, this is a long one. All right, I'm gonna pull it up and then I'm gonna read it again. Cindy Morel Bacon said, "How does a judge view a father that just stopped showing up to see his young children over 10 weeks ago? My daughter's recent ex hasn't seen their boys since January and only 5 times in January. He hasn't made any effort to see them at all. He recently deleted and blocked her on social media and cut off communication with her. She has begged and pleaded with him prior to this to make an effort to see their boys. He has a strong history of emotional and mental abuse with my daughter over the last 6 years. Their boys are ages 1 and 4. The 4-year-old has sent his father voice messages asking him to come and see him and his brother, but he doesn't respond. He at one point through text messages said he would sign over his rights if my daughter would stop messaging him. Of course, she said she wouldn't allow him to do that, but he has since said, why should he change the fact they don't know him? Why introduce himself when they don't know him? My daughter doesn't want to push him over the edge because he suffers from mental illness that he refuses to seek help for, but she doesn't know what her rights are to protect her boys from the inconsistencies and emotional and mental abuse that she has suffered from him and fears he will turn it towards the boys. How do judges in Virginia view this kind of situation? She wants him involved, but clearly he isn't with them if she isn't around. What are her rights in protecting the children?
Well, I think I'm just going to answer the overall kind of the umbrella over that whole question. Judges can order visitation and they can put it in place. They will rarely force a parent to exercise it. So, and what they'll do if a parent is not exercising it, if the custodial parent goes back and says, look, I'm constantly in limbo because this other parent's not showing up for visitation according to the schedule. I can't make any time to do anything. They will sometimes modify it and take away visitation if the other parent's not exercising it. So you've got this situation where dad is just not visiting. He's not wanting to be a part of it. It's probably, I don't know anything about the Virginia laws or how that would work. You'd need to talk to an attorney there, but it's probably going to be hard to get a judge to force him to exercise visitation. I don't know that you're going to get that. On that note, the behaviors you're describing, I don't know if it would even be healthy for the kids to be around the father the way he's acting. I think if you are wanting him to be involved, my suggestion would be to talk to an attorney there about filing some kind of motion for what we call reunification therapy, because I think dad needs to, I don't think he has a grasp on how his behaviors are hurting the children. He needs to think about that and change his behaviors in a way that are healthy for the children, not hurtful for the children. And a reunification therapist or some kind of other counselor or therapist could help him understand that a little better. And I think if you're going to I would be a little worried about at this point with just reintroducing the kids to him. I don't think he understands how his behaviors are affecting the situation.
And that's a tricky one. Not saying that in this particular situation, but I've seen it before where one parent is saying, "Oh, I'm begging them to see the children, but I don't trust them with the children if I'm not around." Almost like I want to be over them. I want to control when they're there. I've seen that very common in alienation. And,
Yeah.
I don't know.
agree. I agree in that question, though. It seemed like she was genuinely wanting
Yeah.
him to be around, and that the kids are wanting to see him. I didn't, you know, so that seems a little different. But you're right. Alienating parents will do that. They will engage in behavior where they, I just don't think it's healthy for you to be around and that kind of thing. They kind of gaslight a little bit.
Absolutely. Denise Freedom said, "How to get visitation with my daughter. The mother won't let me see my daughter. She is trying to get another man to adopt her. This has been going on for 3 years. The judge said supervised visits. Mother refused to let me see my child. I pay support. Can she have this other man adopt her without me? This is David G. I'm using a relative's Facebook."
No, she can't have the other guy adopt her without you. You'd be entitled to a hearing to show that it's in the best interest that the adoption not go through. So if there is an adoption filed, you're going to have to be served with those papers. So you'll have your opportunity to get an attorney and present your case. So that's no, you won't have an adoption out from under you or out from under your feet, as we say, without you having your opportunity for your side to be heard.
Yeah. Standing Wanderer said, "Hello from Ireland. We got some of the Irish up in here."
Get some Guinness.
Yeah, that's right. Kurt Sutton said, "What part of Arkansas is Kevin located?"
I'm in Fort Smith, Arkansas, which is right on the Arkansas-Oklahoma line. We have an office there, and we also have an office in Northwest Arkansas up in Rogers.
Yeah. Jeremy Trent said, "The family court in Campbell County has issued a protective order against me, the mother, not my son. The mother is pregnant again, 5 different children, 3 different dads. When there's no judge admitted, no abuse, violence whatsoever. How can a protective order be issued and also harassment charges for a phone call to check on my son?"
Well, it can't. If that's all that's happened, and there's no either threats of physical harm or the actual physical harm happened or something along those lines, then normally a judge will not issue a protective order. So you may want to appeal that if you've got time to appeal it. Usually a phone call just to talk to the child or check on the son is not nearly enough. Now, if there's history there of calls being made in the past and you've been warned not to do that and you do it again, then sometimes they will issue a protective order or harassment charges. But normally just on a one-time thing, that's not enough.
Yeah. Jeremy Trent said, "Please help. Nobody will help or listen. No one cares. Mother has slowly tried to get me out of my son's life. She tried it with me. I am in Virginia and dying to spend more time with my son." Dude, if you got a question, bring it to us. We're here. We're listening to you. I would tell you to get inside the Dad Talk Today support group where you can talk to other parents that are going through these issues and get in there and just know you're not alone, man. You're not alone. There's definitely people that's here and that cares. And this process, alienation, family court, makes you feel like there's nobody there. Nobody's listening. Nobody understands where I'm at. I guarantee you, dude, there's millions of parents going through what you're going through right now, as you see on this thread right here. So I know he didn't really say. Yeah, I know he didn't really say a question, but I wanted to touch on that.
Well, I want to add too that some of the experts that you and I talk about a lot, Eric, and I don't know if you want to say their names or not, that are parental alienation, the hierarchy basically of the parental alienation therapists across the country, your Amy Bakers and those kinds of people, have started coaching. And so someone like the last guy that we were just talking about, I missed his name now, or anyone out there, if you are a targeted parent, you're the one that is getting the parental alienation directed at you. There are these therapists out there that will talk to you on the phone. They have a fee for it, but they will coach you through. They will coach targeted parents on how to cope with this situation, how to deal with the alienating parent, how to talk to your kids. They can help you because this is it's a form of abuse to you. It really is, and you need help working through it. I would suggest support groups like Eric just talked about that he's got. And you may want to talk to a coach too to help you through it.
Yeah, Jeremy, I mean, you're not alone. I went through it too, bro. I had to, I was in a pretty bad place. I had to go and get a counselor. And some people are against counselors because they're afraid to get brought into the court case and different stuff like that. But I say, just like when talking about getting an attorney, do your research. Make sure you get a counselor that's well-versed inside parental alienation and knows what you're going through.
Yep.
Stuff like that's critical, man, because you can't hold it all inside. It's like a cancer. It'll eat you apart. And you can't live this stuff day and night, man. I mean, you just can't. So I hope you get some help. And like I said, we're here. If you ever got any questions, join us on Monday nights, and we'll make sure to get them to you.
Don't go through it alone. Even if if you're not comfortable going to a support group or talking to a counselor, find friends that are close to you that you really trust, or family. To just confide in them. Don't isolate yourself.
All right. So Jeremy said, how do I prove when the judge will not listen? How do you prove alienation? We've talked about the behaviors and making sure we're getting those out. What's some advice you could give to him, Kevin?
You've got to get an attorney that can handle these kinds of cases and knows how to present this evidence, and you've got to get it in front of the judge. You've got to get it presented. You may need an expert involved that is an expert in parental alienation that can talk about what mom is doing, what kind of behavior she's engaging in. That's how you're going to bring this all home in your case and really get it across to the judge what's going on, what's happening in your day-to-day life.
Absolutely. Matthew Edwards said, what should I do to make an impact? Run for Congress? What do you recommend? I'm serious. Dude, if it's running for Congress or if it's running for office, we need more people that know these issues to run for office. I can't answer that question. I don't know that Kevin can answer it for you, but there's somewhere that you have a talent, you matter, and that you can bring a voice to what we're going through. We need more of our men to speak up and to get involved in this.
Well, the reason I kind of chuckled there is because you're sitting here with a guy, not me, it's Eric, that's going all over the country, shouting from the rooftops about these issues and getting congressmen and local legislators and everybody he can to listen. And hey, man, Matthew, you don't have to change the world all at once. Start where you are locally and just start building. And yeah, if you want to run for legislature, Congress, whatever, just do it.
And small steps matter, guys. I think sometimes people just want to go straight to the top. And if they're not affecting the whole country, it's not meaning, do one person at a time, getting in here, being a mentor, talking to somebody. Sometimes these alienated parents, what they need more than anything, and it's really hard because we've grown and I haven't been able to do this like I did in the very beginning. They just need a listening ear. Someone that they can vent to, man. They need to talk, just like we was talking about with Jeremy a second ago. Come in here and offer a listening ear to some of these parents, and you guys get in here and converse. One thing I would like to see, Kevin, is local levels making support groups, like in-person support groups. It's one thing when we're doing it over Zoom and we're posting memes and different stuff on social media. There's this sense of community that you get in person that you cannot get over a computer. And you guys find it, start it,
Yeah, absolutely.
All right. We got the last question for tonight. We've been going for about an hour and 15 minutes. It's been a great night. Sorry, guys. I went on vacation last week, but we're back. Join us tomorrow night for Dr. Ben Carson. It's going to be a great interview. This one comes from Bobby Burke. He said, can custodial parent take the child on vacation for a week across the country without informing the non-custodial parent?
Everybody's order is different. To me, it's not good co-parenting if you don't at least let the other parent know where you're going with the child. Normally, each parent, custodial or non-custodial parent, especially in the summer, are allowed to take a vacation or two with the children and go out of the state, go pretty much wherever they want, as long as it doesn't violate their order. And it's obviously just common courtesy and good co-parenting. If you're going to do that, let the other parent know where you're going, how long you're going to be gone, where you're going to be staying, whatever. Most of the time in the orders, it says you need to either confer with the other parent or let them know. So can the person do it? Probably yes, unless the order says otherwise. But I don't think it's good co-parenting. You really need to let them know where you're going.
That's it. iTumbler said, Dad Talk Today, Eric, please run for Congress in Georgia. I live in Metro Atlanta and would love to help you. I tell you, man, you're hearing it here first. If I do run, I'm going against.
Do you have an announcement?
Oh, yeah. I'm going to run against Brian Kemp. You think I'm crazy? one day, but we got to get this done first. There's a lot of stuff going on across the country, and I believe we need it done. Kevin, if anybody wants your services or would like to talk to you about getting you on Pro Havice, I know you can go to all 50 states. Where can they reach out to you?
Yeah, we handle high conflict custody cases involving parental alienation, false abuse allegations, anything like that that's high conflict custody type issues. We handle those cases all over the country. We get hired and enter that state in your case, and through a process called Pro Havice that allows us to be admitted to the bar of that state for that case. And we work with your local attorney on that. You can go to kevinhickeylaw.com. That's all one word, and read more about our services there. Our phone number is 479-434-2414. I am on Facebook. I'm on Twitter. I'm on LinkedIn. Send me a message if you have a question. I'm not on LinkedIn as much. If you want to get in contact with me through social media, it's usually best through Facebook.
There you go, guys. And come join us Friday. We'll be at the Capitol in Boise on the 8th. We've got a lot of legislators that we're going to talk to. I want to see something about a John's Law against false allegations. It's a good thing we talk about shared parenting a lot. Iowa just had a bill that progressed that went through the House against false allegations and getting some consequences in there. Yeah, it's about time. It's, I think we need.
Yeah, there's some states that have laws against that. And certainly some states have a list of custody factors, and they've got it listed in there that if one parent has made false allegations against the other one, that weighs against them in the final custody determination, as it should. So
yep.
That'd be good.
So we're going to be talking to them about that. Yeah, we're going to be talking to them about that Thursday. Friday, we got the rally. We'd love to see you out there. Saturday in DC, guys, we're starting off next Monday in Maine. We're hitting Vermont. We're hitting New Hampshire. We're hitting New York, Boston. I forget where all we're going. And we're also going to be in Pennsylvania. So there's many chances. If you guys live out in those areas, come and meet up with us. We need as many people there as possible, and we'd love to meet you. We'd love to talk to you. Other than that, Kevin, I guess we'll see you Friday, brother.
I'm going to see you soon, man. Looking forward to it. 8 a.m. Lewiston, Idaho, Friday.
Man, that's it, guys. We'll see you next time. Thank you for joining us tonight. We are fighting for the rights of parents worldwide. If you want to help support our podcast and for us to continue this mission, please join us at patreon.com/DadTalkToday. You will find us on Facebook, YouTube, Instagram, Twitter, CloutHub, Parler, iHeartRadio, Stitcher, Spotify, the podcast app, Google, Apple Podcasts. We're a little bit of everywhere. And guys, every time you like and subscribe, you help us continue this mission. Thank you, and we will see you next time.